Therapist Thrival Guide, where we cover all of the things that graduate school didn't teach you. Welcome to the Therapist Thrival Guide. I'm your host, Miranda Barker. I'm a licensed clinical social worker, and I am joined with my co-host, Volini, Dr. Lucas Volini.
Hello.
LMFT, and...
What do you mean?
Well, last time you said professional recreation or recreational
Oh no,
golfer.
I was a corporate executive last time.
Oh, that was what you were last time.
I'm a corporate sellout today.
Corporate sellout today.
Yeah.
There you go. Interesting. I'm going to do that every episode, so you just need to be ready for it.
Okay.
All right, perfect. Today we are talking about high conflict or court-involved families and how to navigate some of those relationships, especially if you're a first-time therapist or an early therapist and you're trying to figure out how to best support your client, how to keep those kids centered. And so I am so excited to be joined with Deb Link. Deb, do you want to go ahead and introduce yourself?
Sure. So I'm an LMFT, and I work almost exclusively with this population. I have other clients as well, but mostly do therapy with clients who are somehow connected to the court system. Could be people who are, just starting out in divorce and they're individual clients who are looking to kind of build identity. Could be family therapy, co-parenting work, working with kids and teens. And then about the other half of my practice or so is forensic in nature, and I do custody evaluations, parenting coordination, which is something we'll talk about today, and mediation, and other different types of services that are sort of auxiliary services that the same families need to access, essentially.
Gosh, so you do it all.
I do a few things. I don't like doing the same thing all day long, right? Like so I mix it up.
Yeah. How did you get started in this aspect of therapy?
Yeah. Well, I was always interested in sort of the intersection of the legal system with therapy, and I think that's because my dad is an attorney, or was when I was growing up, and so a lot of people were intimidated by that world, but I kind of understood it enough, right? And so I first thought maybe I would work in like a prison, with folks who had been on that side of the law. And then I got interested in mediation, so I got, trained to do that. And there were a few people, attorneys in my area, that knew I did mediation and said, hey, would you ever consider doing this thing called reunification therapy? And I said, well, what is it? So they described that sometimes after a divorce or separation, the kids will over time reject one of the parents and not have had contact with that parent for quite some time, and that oftentimes the judge will order kind of a family therapy on steroids sort of thing called reunification. And so they said, well, would you try it? And I said, well, how do I get trained? And they said, well, there really isn't any training, but go talk to those folks that do it really well up at Moxie, and they'll tell you how to do it. So I did, started working in that, and then from there, really kind of understood that there's lots of different specialties within that court-involved work, and so I've just kind of one at a time added different trainings, and here I am.
So interesting. Okay, so you were drawn to it because your dad was an attorney. Was he a divorce attorney or somewhere in that?
Yeah, he I don't know that that's all he did. I should ask him that question. I don't know. I know he did family law. I don't know if he did exclusively family law, but I know he did family law cases. And I just from picking up on things, I knew a little bit about, what's a judge and what does it mean to testify, and, these different words that most kids probably didn't understand, Yeah. And then I also think that attorneys sometimes have a particular type of personality that's really intimidating to therapists. But for me, it was like the kitchen table, like how my dad talked, right? Like, so I don't know, it just made sense.
Yeah. So you were that sounds great. I do not specialize in this, so I'm so glad that you're here, because we wanted to dive a little bit deeper into, important topics around this. So like confidentiality, records, roles that a therapist might play, as well as like how to keep the kids centered in all of this. And so I would love to hear from you. Why do you think this topic is so important?
Well, I think when we ask that question with anything in therapy, it should always be a client-centered answer, right? So this topic is important because the kids in these situations are incredibly vulnerable. For people who are familiar with ACEs research, one of the ACEs is your parents separated or divorced. So these are kids that automatically have an ACE. What we know is that they're statistically more likely to have many more ACEs. So these are not just vulnerable kids in the sense that all kids are vulnerable. These are kids that have layers of vulnerability. And a lot of times when they come to like the services I offer, they've been exposed to all kinds of toxic conflict for a long period of time, which we know can impact them through their lifespan, not just their mental health, their physical health, their relational well-being. So the protection of those kids and the advocacy, not that we're in an advocate role in this situation, but in general, the services we provide are for the kids, right? And for their well-being. So that's the first reason that this is incredibly important. The secondary reason is for the protection of us in the field, that these are highly litigious clients. There are a lot of times parents that solve problems through filing things, which is why they're there, right? And so they are not hesitating to file a board complaint or all kinds of creative Better Business Bureau. I mean, I've got them all. This is how they solve issues when things happen that they don't prefer, right? And so I think therapists find themselves before the board having to explain what they did on these types of cases more often than on other types of cases. And that's even tricky because the decisions a therapist has to make both clinically and ethically are so complicated in these situations. And so I've always said that really good therapists find themselves tied up in sort of a yucky mess in these situations and could have prevented that if they just had some very, basic guidance up front, right? So I think that's hopefully what this can provide today.
Awesome. This is so important. Why do you think therapists, I think you kind of answered this a little bit already, but why do you think therapists shy away from these cases so much?
Yeah. Well, at first blush on the surface, I think it's because they're worried about attorneys and testimony and court. They see attorneys as people who are ready to sort of twist their every word to nail them to the wall. And there are some attorneys that are like that, right? But, there are a lot of family law attorneys that are trying to come up with collaborative and reasonable solutions to problems for real families. I think another piece of it is that we don't know how to interact with that world, like subpoenas and what am I supposed to say and not say and how do I respond and not respond. There's a lot of rules, and I think everyone's sort of afraid of breaking one of them, so they don't even want to touch that with a 10-foot pole. I think a lot of people do know colleagues who've gotten reported for these types of cases, so they're afraid of that piece. I think a lot of people... this is something that we should teach more in graduate school, but we don't. So people don't feel competent, right? Like this is a competency-based field, and we're not supposed to be doing work that we don't have any sort of knowledge in. Most people don't have any specialized knowledge or training in this area and aren't real motivated to get it because it's such hard work. It requires a lot of time outside of sessions. And I also think... I don't know if subconsciously therapists are aware of this or not. I think this work touches so much of our own stuff, right? Like so many of us have our own experiences of parental conflict. Lots of us come from divorced homes. But divorce brings up a lot of other more abstract things like grief, right? Like all kinds of different things that we work through as our own humans. And, this work sort of invites you into all those spaces, right? And there's a lot of self as therapist work that you have to do this work.
Yeah.
And what percentage of clients, for as close as you can put a guess out there, are court ordered for these services?
I would say that there's those who are court ordered. And then the actual vast majority are not court ordered, but still don't feel like what they're doing is voluntary. Because what ends up happening is their attorney says, look, we can go spend $10,000 on this motion, and then the judge is going to tell you to do X. So in order to look compliant, we're just going to do X. And clients don't necessarily feel like they should just say no, right? So I would say I work with very few people who want to be working with me, even if some of them don't have a court order. Now, the vast majority of them have a court order. The vast majority of those court orders are called stipulations, which if you see that word, it means that the parties agreed to what's in that court order, and then the judge kind of rubber stamped it, right? But even those stipulations, most of the time, those clients don't feel like they had any other choice except to stipulate. So this really does feel like involuntary work almost all the way around.
Sure.
There are some times, like, so if I'm doing earlier I used the word reunification. We're really not calling it that anymore. That's the word that people used back then. But now it's typically called resist-refuse therapy, or some people in Minnesota here are calling it parent-child contact therapy. So there's some terms popping up. The term reunification is problematic for a number of reasons. But in those situations, you always have one client who's very voluntary, and that is the parent who's not seeing the kids, right? And so it's not that there are no voluntary participants, it's that in every system, there's an involuntary force, which is exerting pressure on the work.
Sure.
Yeah.
Well,
Which is a big deterrent for a lot of people, I can imagine. I mean, joining with any system is difficult.
Absolutely.
It's significantly more difficult when none of them want to be there.
Yes.
And also, too, kind of, it makes me think of the common factors research on how much of the attitude that the client brings in and their internal resources are how much they're a predictor of effective therapy. And so these aren't cases that you are going to be getting a lot of direct self-esteem from.
No.
You know, from the perspective of, you know, it's like they're a mess. You work with them, you clean them up. They're so grateful, you know, and thank you.
No one likes you.
Yeah.
There's always, yeah. I mean, and I think, you know, I just watched a rebroadcast of a really great training that happened in Minnesota in July, and they were talking about how there's a big difference between supportive therapy and challenging therapy. And most of these folks have, at some point in this process, engaged in some therapy, but most of the time supportive therapy with an individual therapist who's doing what most of us do all day long, right? Just trying to support them and cheerlead them and help them be the best version of themselves they can be. Then they come to this work, and it's incredibly challenging. It's not supportive, and it's sort of simultaneously challenging to every part of the system. Like, you're putting pressure on every piece of it at the same time. When you're doing the family systemic work, right? And so then when we're talking about children, which is what we're talking about today, you're talking about parents who are oftentimes involved in this very challenging work themselves, and then you're asking them to find capacity and resource to support their kid, which is really hard.
Yeah. And I think one of the big reasons why I wanted to talk about this too is because regardless of if you as a therapist specialize in this work, you are going to run into the cases.
Oh, absolutely.
Like this.
It's coming to your office whether you like it or not.
Exactly.
Yes.
And so it's less about what are all the certifications I can get? How can I add these people to my caseload? It's more about when they come to your caseload, how can we respond? How can we be educated? What do we need to know?
That's 100% true.
Awesome. So let's kind of take a step back. And I know that one of the things we talked about was the who's who and some of these different roles within these cases.
Oh my goodness, yes. It's like learning a whole new language of acronyms and titles. Yes, yeah. Yeah, so, I mean, one thing I will say is that this varies a lot jurisdictionally. So obviously I'm really familiar with Minnesota. I do, attend trainings with people from all over the United States, but I don't know their jurisdictions intimately. So some of this can kind of vary from state to state. But a couple of, I think, things to be aware of. If you're, from the perspective today, we're talking from the perspective of a child therapist. So obviously you have the parents, they're major players. You have the attorneys a lot of times. Now, sometimes parents, one or the other, will be a self-represented litigant. And most of the time they have attorneys. When they initially separate or a divorce is filed, a lot of times in many states they're required to do some form of what's sometimes called ADR, which stands for Alternative Dispute Resolution. And that's just kind of, the word alternative basically means anything that's not court. And so mediation is a popular one throughout the whole United States, and the different states have different forms that can take. Here in Minnesota, we have something called like a social early neutral evaluation. That's kind of a form of early mediation. Throughout the different states, they may have different programs and terms. So there's sometimes a mediator. That person will probably never interact with you as a child therapist because they don't collect outside information, and it's a completely confidential process, right? If mediation can't solve things and the family is kind of moving more towards hearings and court dates and maybe, a divorce trial pending, you might start to see a lot of other people get involved, like individual therapists for the parents or some sort of uncoupling or co-parenting work. And it can be really important to do some collaboration and continuity of care with some of those folks. We are going to talk later about safe harbors, and I think that's really important to have in place before you do those types of things. And then, as you go down the line further, one important role for a child therapist to know about is called the parenting coordinator. So in Minnesota, my understanding is the 49 states other than Minnesota call this a parenting coordinator, and then Minnesota just decided to make up our own term. So here it's a parenting consultant, but it's the same role, okay? Huh. And this is something I think it's really important for child therapists to understand. This person is in a decision-making role. So when you hear a coordinator or a consultant, you usually think of someone who's giving feedback or ideas, coming alongside as a guide. I think about, the word consultant in a corporate setting and what that means. But this is a decision maker. So this is sort of like almost like a mini judge. And this person is different from a mediator or a judge because they do collect a lot of information. And one of the first people they're going to call as a collateral resource is you as the child therapist. They're going to want to hear from you. So one of the things that you need to understand is whether or not they have a safe harbor, whether or not the information you're giving them is confidential, whether it may end up in the hands of the parents in court documents that are a matter of public record, that sort of thing. But that person is going to want to hear from a child therapist because they make the decisions that the parents can't make. So when mom and dad can't figure out if little Johnny's going to play soccer this year, then the parenting consultant decides if little Johnny's going to play soccer, right? And so that person, they're interested in the perspective of the child therapist very often. Sometimes those are people that come along while the divorce is still pending. Sometimes those parenting consultants come along after the divorce is already long done. Another person who will want to talk to you as a child therapist is the custody evaluator. That role, they don't make any decisions for the family. They make recommendations. So they come alongside the family, gather all kinds of information, and write recommendations about what should happen with custody, who should make decisions about the children, who should have parenting time with the children, in what schedule.
Do those recommendations go to the judge then?
Yes, so those recommendations are heavily weighed by the judge, and they're based in different states on different factors. And so, that person is making recommendations. This other person over here is making decisions. And one of the things we're going to talk about today is that as a child therapist, you should be doing neither of those things. You should not be making decisions, and you should not be making recommendations about things like custody, right? But the people who are doing those things are going to be interfacing with you and constantly wanting information from you for a good reason, because they're interested in the kid who's at the heart of all of this. And you have information that's considered more neutral about the kid, right? Because it's not information channeled through mom or channeled through dad.
Right.
So we're going to talk today about, the confidentiality of all of that information you have and how you interplay with those different players of the game, right?
Well, did you have any more roles or people that
I think those are, I don't know if you guys can think of any that you've ever come across. I think those are probably the ones that are more likely to call a child therapist and try to get information.
What about a guardian ad litem?
Oh, that's a really good point. Yep, there we go. That was on my list, wasn't it? So a guardian ad litem is someone who's appointed by the court. Now, many states actually have attorneys for the child. So the mom has an attorney, the dad has an attorney if they hire one, and then there's an attorney appointed for the child. And then that's different than a guardian ad litem. A guardian ad litem is appointed on behalf of the child to represent the best interests of the child to the court. And they also make recommendations. They're much more like a custody evaluator. They don't make decisions. They make recommendations to a judicial officer who makes decisions. And they specifically are there to represent the best interests of the child. They're getting more and more rare, unfortunately, throughout the United States because of lack of funding. So they're oftentimes not appointed, except in cases where there's, really, really big concerns, like a potential childhood sexual abuse case or something like that. But they are sometimes used. And like I said, then there are states where there are attorneys appointed for the child. And, I think that my understanding is that one of the things that makes a guardian ad litem different is that they are really there for the best interests of the child, which may be different than the child's preference. The child's preference is not always their best interest, right? So they're not there to just advocate for what the child wants. They're there to really consider what the child needs, that the child may not have the capacity and developmental, they just developmentally might not have the capacity to know what they need.
Oh, yeah. Yeah. When I was in child protection, I routinely had, your guardian ad litems, your children's attorneys, and all these different players. And there was this one case I had where there was a 13-year-old who was very insistent on, I think it was, a lot of different things, but particularly what school she went to. And she told her attorney that she wanted him to be arguing to go to this school and this is what she wanted. And the guardian ad litem was like, that's not in her best interest. And then decided, my recommendation is this instead. Right. And so that's kind of the example that I'll often use, the school thing.
Yep. But yeah, and in Minnesota, I've never had a case with a child attorney. It's just not a thing here in Minnesota. We don't do that, right? But when I go to national conferences, I meet people and one time I met somebody that was there and I said, what do you do? And she said, I'm an attorney for the child in Iowa. And I said, attorney for the child? That's interesting. We don't do that here, apparently.
Well, so in Minnesota on child abuse cases, we're required to give kids an option, but it sounds like for
divorce, for family court, right? Because I think child protection is part of juvenile court. Yep. So this is completely different. So, yes, for these cases we don't have that. Yeah.
Interesting. Yeah. So let's jump into confidentiality with some of these roles, because I feel like you were kind of teasing it, and this is so important to know as a therapist. Who can I talk to? Where do who signs the releases of information? All of this sort of stuff.
Well, I think there's sort of three pieces to this. There's informed consent. What do you need to know to get the appropriate informed consent? Then there's release of information. And then there's access to records. And those are three completely different questions. So the same person we probably should start with informed consent, because the same person who has to give informed consent is the person or people who would authorize access to information about the child. So in states across the United States, there's sort of two different pieces of custody, and all the states have different labels for it, but typically one has to do with decision making, right? So in Minnesota we call it legal custody. They have different labels throughout the United States for this, but it's essentially who makes the major decisions about the children related to big things, right? Like their education, their religious upbringing, their medical care, their mental health care. And that can either be sole decision making to one parent or the other, or joint decision-making. And I think one of the biggest misnomers that happens amongst therapists is this idea that no matter what that custody arrangement is, you just need one parent to sign your informed consent forms. And I've heard, reputable ethics trainers say that you only need one person. But LMFT has been very, very clear. And, I'm a marriage and family therapist, so I, pay attention to what LMFT says. They've been very clear that if people share joint decision making, you need both signatures as long as you can possibly get them. Now, obviously, if you have, say, an incarcerated parent or, some sort of situation where you can't get that second signature, you need to balance that with the ethics of, doing harm by not providing care, right? But you need both of those signatures because neither one of those parents should be acting unilaterally from the other one. And this is where you get some board reports come in, where a therapist starts therapy with only one signature. And now you have this person who has equal say in the decision-making around a child's mental health care that has no idea that this therapy has taken place and the decision's been made without them, right?
And you don't, in those situations too, the provider is only going to be partially informed of the reality of the child's life.
Right.
So that complicates, like when you work, you can't rely on kids to be a complete self-reporter of everything going on. And so when it's a divorce, it's like you can safely assume there are going to be two different stories of how it got there, what's happening, what they're experiencing as far as their relationship to the kids. So that's a big piece of it. And just to, I just want to make clear, like when it comes to confidentiality, that's all ultimately determined by your state licensing board.
Absolutely.
So like LMFT is a professional association, and their code of ethics is enforceable only to members, and it's not tied to the license, but professional associations tend to write this stuff in more of an aspirational best practice kind of way.
Yes.
So even if the state that you practice out of doesn't require two signatures, you still have every right to practice based upon whatever standards you want to practice from. And this is a big one to keep you out of trouble.
It's a safer standard. Yes. Especially because not every state has laws that make it entirely clear which parent has to sign or if both have to sign. And so I think that it's safer to kind of, and I wouldn't just say safer from an ethical standpoint. I think that it sends a message to the family, to the child, and then ultimately like back to yourself as a reminder that this is systemic work ultimately, right? Like you might be the child's individual therapist, but that child is in a system. And that both of these parents are a part of that system. And when you set that up from the beginning, it changes the culture and the atmosphere of the work you're doing with that child. It balances it from the very beginning. So yes, not only do you want to have signatures, you want to have input at intake from both parents, right? So kind of moving to then release of information, the same thing, at least how I practice, the same thing for me is true, that if I'm going to take information from a child's chart, PHI, protected health information, and give it to a third party, I personally am not going to do that without the permission of both people who have decision-making authority over that information, right? Because ethically and legally, I don't think that's right. And also, morally, now you're acting independently. You're allowing one parent to act independently of the other parent, which is counterintuitive to the systemic goals most of the time. So I always get both signatures on those releases of information for outside parties. Now, most child therapists operate with some sort of safe harbor, okay? And I think this is incredibly important to talk about for this particular topic. I sort of have a love-hate relationship with certain parts of it, and so I have a very specific way I use safe harbors. So the idea of a safe harbor is it's a document that basically says that what the child shares in the therapy room will stay in the therapy room. It will be confidential. Essentially, parents have rights in general, and this is once again guided by all of your state laws. But in general, in the United States, parents have rights to information about their own child's medical care. And because we have decided in the infinite wisdom of someone that mental health is considered part of medical care under a medical insurance plan, it's considered medical information about the kids, right? And so parents technically have access to that. A safe harbor is sort of a document that a parent signs where they give up their right to that access, right? Now, obviously, all of your rules about client dangerousness still apply, right? Like if the kid you're working with is suicidal, homicidal, that kind of thing, you're still going to share that information. So a safe harbor needs to say these exceptions still apply, right?
There's never an exception to
No,
mandated reporting.
absolutely not, right? And so safe harbors are not a way to circumvent those duty to warn and mandated reporting. They are a way to kind of create a container for all this information from the child and try to safeguard it from showing up in court documents that can become public records or being weaponized between the parents, which is truly what oftentimes happens. However, there are times in which that information should be shared with one parent or the other, right? So let's say that, the child is having a behavioral concern at home and has given the therapist a little bit of insight into what's going on underneath the surface with that. We don't want this safe harbor to handicap the therapist from being able to share some information with the parent that will help them parent the child, right? So I think it's very important that these documents talk about that it's up to the discretion of the therapist to share information with the parent, and also that they don't have to share the same information with both parents. Because sometimes there's a concern going on in one home that's not going on in the other home. So they're working on coaching with this parent about something, and they don't necessarily need to have the obligation to schedule another phone call to run back and tell this information over here that's irrelevant. Mm-hmm. The other thing is that we just talked about how parenting consultants are making decisions about this child, right? They are deciding sometimes where the kid's going to go to school, what their parenting time schedule is going to be, whether they get to go to summer camp, whether they get to participate in certain activities. And the voice of the child is immensely important to those decisions. Now, the voice of the child should never make the choice, right? These are adult choices. These adults who are making the choices, whether it be parents, judicial officers, parenting consultants, they should be listening to the voice of the child in the process. Well, how does that happen if there's a safe harbor? Because then all we have is the kid talking to one parent and the other. Mm-hmm. And 9 times out of 10, they're telling each of those parents completely different things. Mm-hmm. So that doesn't help us. So with safe harbors, I have a clause in mind that also says that if I believe that it could be beneficial to the client, because that's always our ethical standard, mm-hmm. right? I can talk to those professionals and give those professionals information. Now, when I'm doing that, I'm always mindful of what is that professional's process confidential? Okay. Mm-hmm. So we talked earlier about 2 kinds of professionals that will oftentimes ask for information from the child therapist. One is a parenting consultant and one is a custody evaluator. Now in Minnesota, when a parenting coordinator or consultant is appointed on the case, basically, there is a model language that goes into our orders in Minnesota that says that the information from a child's therapist goes into a separate file in the parenting consultant's file, and there is a protective safe harbor around that file, and it can only be given up if the judge orders it. Okay? So when a child therapist tells me information as a parenting consultant, that information stays confidential in my file. Okay? Unless, and the court order says this, the parenting consultant and the therapist agree that the parents should have that information about the child. So we're always creating these loopholes for necessary information to come through while we're protecting information that doesn't need to be shared, right?
Sure. So I guess I just have this would be something that would come up for me all the time when I was seeing more clients regularly. And if I have a parenting consultant reach out to me, do they need a release? That's an excellent question. So the parenting coordinator or consultant role is guided by a court order. So in Minnesota, it's like an 11-page template, okay? In Minnesota, that court order says that the parenting consultant doesn't need a release to talk to anybody about anything, right?
But most of us know that you all, need them. Schools need them because of FERPA laws. Medical and mental health professionals need them because of HIPAA laws. So ultimately, we are almost always getting those releases signed and circulating them. But no, the parenting consultant doesn't need a release to tell you anything or to hear anything from you about any family member.
See, that always felt like a trick to me. I don't know. It's so odd to me after like just operating from a place of like everyone needs releases. I don't share information. That was always so odd to me.
Yeah. No, that's real.
That.
Yeah.
And so you need to include that court order into your clinical documentation.
Yes, and I've never worked with a therapist who didn't also still get their own release, which I completely respect, right? Because the court order doesn't say that Joe the therapist can talk without paying attention to HIPAA laws. It says that the parenting consultant can. So the therapist still needs the release, which is totally fine.
Yeah, don't take their word for it, So if they're saying I'm court-ordered parenting consultant, it's like, okay, let me get a copy of that court order, review it, make sure it's legitimate. That could function as your release of information. You could also get one on top of it for...
Yeah, I mean, I will say that when I'm operating as a therapist, I do not allow the court order to serve as my release of information because the court order doesn't say anything about me as a therapist having permission to speak. It only says that the consultant, the parenting coordinator or consultant can speak. And so I always get that release anyway. Yes, absolutely. And I've never had a PC that didn't understand that. They're always happy to wait for you to get the release. So ultimately, that process is one where information can still stay confidential if it says so in the court order. So in the varying states of folks that are listening, you're going to want to get that court order, like Lucas is saying, and look for that. If you give information to this parenting consultant, does it stay confidential? Can it stay confidential? Do you have discretion over that? But ultimately, that can be a way for the child's therapist to give information that can, help decision makers understand the child. And that is one of the goals of the PC process, right? So PC is what we call a parenting consultant or parenting coordinator. The judge is not calling up, Susie's preschool teacher and Johnny's basketball coach like the PC is. So the PC can get more personalized information to make decisions for the family. It's part of the draw of that role, right? That's part of the reason families pay for it when they do. So you want to participate in that as a therapist without compromising the confidentiality of your client. Now, custody evaluations are totally different, at least in Minnesota, and you'd want to check this out in your own state. They're not confidential at all. Like whatever you tell that custody evaluator, that's going in the file, and that file is subject to discovery.
Got it.
And so you have to be very thoughtful about what you share.
And when you say subject to discovery,
subject to discovery, that's a good, see, I just have this lingo that just comes out of my mouth. That means that the attorneys can subpoena that information, which basically means ask for a copy of it, and it can be utilized within the court record and within the court proceedings. So, so I think that safe harbors, they need to allow information to stay confidential, but there needs to be a conduit for parents to have information they need to parent, for professionals to have information they need to do their jobs. I've seen safe harbors, and I have one that I've used that says that the child therapist won't go testify. I'm going to take that out of mine because I do think that there are times where it's actually in the best interest of that child for the child therapist to testify. Now, if it's not in the best interest of the child therapist can show up to, if they get subpoenaed to court, and just state that they don't believe that it's best for them to break the confidentiality of their client, and the judge can decide. The judge can order them from the bench to talk anyway, or the judge can say, okay, we're going to honor the confidentiality that you'd like to honor, and they may not have to testify, right? So I think that ultimately has to be a case-by-case basis, right? So safe harbors, one of the things that we could maybe link, in the podcast is, a sample for something like that, because these are commonly used. I do believe they're important. I like to use them on cases, and they're tricky because they can stop information from flowing where it needs to flow
Yeah.
for the right people to have the right information to make decisions that are best for the kid.
Yeah, I think that's great, Deb. We can link to one in the description, and so then people can see a sample and obviously then, look into what it needs to include for their own state.
Their own jurisdictions.
But yeah,
Absolutely.
I think that's a great idea. Okay, you have talked about subpoenas a little bit, and like as a therapist, whenever I hear the word subpoena, I'm always like,
yes.
So talk to me about, and this is a question that comes up a lot.
Yeah. Yep.
If who sends subpoenas, and what should a therapist do when they receive a subpoena? Like what does that mean?
So typically an attorney sends a subpoena, and what the therapist should do is different in every situation. So first of all, if the first step I always do is alert my client. I've received a subpoena for X information from X individual. If that person is an adversarial, like say it's the opposing counsel, which means that it's the attorney for the other parent. At least in the state of Minnesota, we are required to respond to that subpoena. But most of the time, what you're going to respond with is, I have received your subpoena. My client is invoking their right to privilege and confidentiality.
Yeah,
right?
and so you have to respond to the subpoena. That doesn't mean you have to do what the subpoena is asking you to do.
That's exactly
you have to
right.
respond by acknowledging that you received
Acknowledging receipt. Yes, so you do have to provide a response, but you do not have to give what the subpoena is asking for. So yes, you're exactly right. If the subpoena comes in and says, I want all of mom's therapy records, and it's dad's attorney, then you can say, I've received your subpoena, and my client is invoking her right to confidentiality and privilege. Or confidentiality is the mental health world, privilege is the legal term. So one question I often get, and I guess it's a good question, is isn't that confirming that the client is your client, right? Isn't that a breach of confidentiality just to respond, right? And ultimately, I don't have all the answers, but the consultation I've gotten around that is that is not a breach of confidentiality because they already know that information. They wouldn't have sent you a subpoena if they didn't know that. So you're not telling them something they don't know. You're just saying, no, you may not have my records. So that's, if you're not going to give the information, that would be your response. Now, let's say that it's a quote unquote kind of friendly subpoena, right? Let's say it's the in my example from before, it's the mom's attorney who wants the mom's records, okay? Then I think it's doing what we would do with informed consent for any situation, talking about the pros and cons, making sure the client understands their rights not to have those records released, making sure the client understands the risks of having those records released, making sure the client understands the purpose of what the attorney is going to do with those records. And if those records are going to be confidential in the attorney's file because of privilege and they're confidential in your file, maybe it's just fine for you to give those records, right? So it's kind of a discussion with the client. If you are going to comply with a subpoena to give records, you need the client to release, right? You need an authorization for release of information per HIPAA to, give those records up. Now, another type of subpoena is a subpoena for appearance in court, right? So this is not a subpoena of your records. It's a subpoena of your testimony in open court. For those, you have to show up. You absolutely are able to, charge the client for that, but you do have to go, right? Once you get there, if you have release of information to testify, so let's say that I'm working with an individual client and they want me to testify about our work together as a part of their divorce proceeding, and they've signed all the releases of information for me to speak about that work, then I go and I testify. But let's say, and this has happened before, let's say I'm a family therapist. I get a subpoena. One party says, yes, please come testify about the work. The other party says, no, I'm not signing your release. So I show up ready to go, like I'm prepared, and I say, on the stand, I'm sorry, I can't answer that question because I don't have authorization from release from each party to answer that question. And each time the judge would either direct me from the bench to answer the question, so now I've been ordered by the court, or the judge would say, okay, I'm going to honor the confidentiality of whichever party didn't sign the release. So it becomes a little bit more difficult.
Interesting. Yeah. And I should also preface this that none of us are attorneys and we
Yes.
can't offer legal advice. But
Right.
I think as a therapist, this is helpful just to understand the different avenues that this could go down and
Yeah.
kind of different responses and options available.
Yeah, it's the attorney that has to give the legal advice to the client about, should they sign the release or not, right? So when I'm sitting in open court with one party who signed a release and one party who hasn't, that's because their attorney directed them likely not to sign it, right? So, I can't make any of those decisions. I just show up and follow my ethics, which is I'm not going to release information I don't have permission to release or that I think is going to harm somebody if I do.
Yeah.
And so I will state that, and then the judge will direct me to do what the judge is going to direct me to do.
Sure. Well, let's switch gears a little bit,
Mm-hmm.
and I want us to talk a little bit more about navigating communication as a child's therapist with different parents. And
Yes.
so if they are in an active custody battle or if they just, they don't get along,
Yep.
how do you navigate that?
Well, I think you navigate it with really strong boundaries, and they have to be clear up front. Now, I shouldn't say they have to be clear up front. Sometimes you will trip through a situation and figure out what the boundary should have been and then set it, and it's never too late to set it, right? So it's not like they have to be set up front. It's helpful if they are. Some common ones for child therapists is that they can't communicate with you without copying the other parent in, because what you don't want is this triangulation of the therapist into the parental conflict. You don't want the therapist to be sort of the holder of secrets, like one parent shares this information and then the other parent's not supposed to know that there's a new girlfriend, boyfriend, whatever,
Sure.
right? Now, I mean, that's not a perfect system because a lot of child therapists do parent check-ins, right? And a lot of times in a situation with a divorce, the parents alternate taking the kid, right? Like one will take the kid to an appointment and then the next week the other one brings them. So a lot of times the child therapist is doing like little parent check-ins for 5-10 minutes at the beginning or the end of the session with one parent or the other. And it's not like the parents are sitting in on those. And certainly they may be talking about challenges that are going on with parenting in just that home. They might do a parent coaching meeting with one parent or the other. But it's important that the child therapist doesn't become the holder of information from one parent that the other parent's not supposed to know. So having them copy each other in if they're going to email you. Having boundaries about what email is, right? Most child therapists I know, they email about scheduling only and insurance. Otherwise, you will get very long messages from the parents about all these concerns about the kid, all these concerns about the other parent. So, I know that there's a lot of child therapists that consistently have to remind parents, like, I don't do therapy through email, right? I also know some therapists who actually prefer to communicate with the parents through email because then, first of all, they can prove parity of process, right? Like I gave the exact same information to the parents at the exact same time. There's no favoritism in how I described it, who I told first, that kind of thing. At the same time, those documents become kind of living documents forever in the case. And so you might be on the witness stand explaining why you said this instead of that and how you worded it. And that doesn't happen when you're, just talking in person. So there's big pros and cons to using email. But I think defining your own boundaries about whether or not you're going to email, making sure that both parents are involved from go, like we talked about earlier, that you have both of their perspectives, setting really strong boundaries, and really repeating over, like repetition is key, repeating over and over again when they start trying to loop you into the conflict. Like, you know what, it sounds like it would be a really good idea for the two of you to have a co-parenting coach because I'm not able to address that particular concern. It sounds important, but I can't address it because I'm so-and-so's individual therapist, right? So really repeating the role and then recognizing that these parents sort of give you, and I don't mean to say these parents as if it's like this blanket stereotyped group. Oftentimes, child therapists receive little invitations from the parents to step outside of their role, right? And you have to get kind of good at recognizing that's what that is. That's an invitation for me.
Like what?
So they may come in and say, you know how like I've been bringing the kid here on Tuesdays, and what you don't know is that Monday night is dad's parenting night. So you know how the kid's been super hyper in the playroom, but today is Thursday. So see how calm the kid is because they were with me last night. So don't you think that we should probably make sure that the custody evaluator knows? Right, and now this is this invitation for you to start commenting on the custody arrangement and whether the kid's better off with mom or dad. Now, certainly a child therapist can make observations, right? I've done custody evaluations where I've called the school nurse and I've been told that they have records of 15 Tuesdays where the kid came to the nurse's office without their teeth brushed, without their hair brushed, and hungry, and that's never happened on any other day of the week. So certainly that's information that a professional and a child therapist could share, those types of observations. But that's different than sort of getting invited into this little hook, this little invitation from the parent to start to form an opinion about the parenting and the co-parenting, and maybe to start to say some things that would be more advantageous to one parent's case than the other parent's case, right? So recognizing those hooks and drawing those boundaries right away sends the message to the parents that you're going to stay in that role, right? So I think staying in your role has a lot to do with how you manage that relationship in the room, but also how you manage the boundaries of email and whether or not they have access to you at all and whether they have access to you privately and all of those pieces.
Oh, those are such good tips. But I think it's hard, it's hard to enforce those boundaries because if you are seeing a kid who is more hyper at this time, the example that you used, it's hard to draw that line sometimes.
And certainly those are observations that you might share with a custody evaluator or a parenting consultant, right? Now, hopefully you would share them only if they're patterns, right? Because as therapists, we don't really want to take a one-off scenario and make meaning out of it, right? But yeah, I think that you typically do, as a professional working with a kid, notice patterns. And I think we can be descriptive within our own clinical observations without being evaluative and without making recommendations. It's the difference between giving information that you've observed and telling the professional what you think should happen because of that information.
It's observational research.
Yep.
When you do observational research, and I remember this is always a challenging assignment for students in research method classes to observe a situation as it's organically occurring, and then to write about that without having anything along the lines of an interpretation, a prescription of meaning, a value judgment. It's just a very black and white documentation of something you observed. And with all of it, a big part of a lot of this work is understanding the role you play in the midst of a lot of moving systems, and in the cases of divorcing parents where it's a contentious divorce, maybe it's a divorce that they've been in for some time. It's they're playing games. It's divorce as it plays out. It's there are a lot of games that are played between the attorneys, with attorneys and clients. Even in the earlier example of a spouse's attorney trying to subpoena the medical records of their ex. It's the attorney knows you can't do that. The attorney knows there's no chance of, but and they're hoping you either don't know that, so you screw up, and even if you get the documentation, it doesn't matter what's in it because now you're totally non-credible with this court case at all. And so you're going to find yourself getting sucked into that game because that's the system that they're predominantly operating in. And so you just need to be aware of that so you can stay differentiated from it, because you don't want to ever clinically document something because a parent asks you to. You also don't want to not clinically document something because a parent asked you to.
Yes. And I think so a couple thoughts there. One is that ultimately what we're doing is providing treatment, right? And so that's what we should be doing. And in the course of that, we are probably going to make observations that would be relevant and helpful to the people who are doing the jobs we're not, which is making recommendations and decisions. But that's not the purpose of the work. It's a secondary benefit, I guess, to the work. But what you're doing is providing treatment. And so that, I think, should help child therapists feel confident, right? They're doing what they're doing in every other case, right? But yes, these systems do sort of draw us in, and I think we need to have a huge dose of humility as therapists that we are subject to that, right? We're vulnerable to getting drawn into the drama. And I think that this is why, if I could kind of leave with a couple of really key pieces here, consult, right? Like consult, because as I said earlier, these cases just stir up all of our own stuff. And we want to like advocate for this kid, but as child therapists, we don't always have all the information. So we need to give our piece of the puzzle and let the person with the whole puzzle decide what should happen, instead of, but we have this like angst, like this, I want this thing to happen on behalf of this kid, right? And so when we start to feel that, right, that's really like consult, have really good documentation, right? So this sounds like your, ethics 101, where we always say consult and document, and it can just like, after you've heard it a million times, like just go in one ear and out the other. But I would say I rely on those two things more than anything else in this work. So important, because we can get sucked in. And I will say, sometimes we're getting sucked into a strategy, like a game or a strategy, right? There's a whole lot of other factors, though, that sometimes parents aren't playing a game. Sometimes parents are triggered by unresolved trauma responses from their own past, and they're trying to protect their kid from something that they don't want to happen to the child while they're subjecting them to something else, and they don't even know it. And so, I think parents own trauma, I just say, when you're talking about divorce, the stakes literally do not get any higher, because we are talking about your kids and your money. And you honestly have to be almost sociopathic if your kids aren't one of the most important things in your life, right? And so most of the time we're talking about the very most important thing to this parent's heart. And then we're talking about their security and their livelihood, because we're talking about their money. And when you put both of those things on the line, and you create uncertainty about both of them at the exact same time, then parents do all the things that humans do when they feel desperate, right? So sometimes they're playing a game, sometimes they're just trying to survive, sometimes they're triggered into trauma, but something's going on that we can get drawn into. And so that's that really important piece of our own work, which comes out of consultation, right?
Such good reminders, and so important for new therapists, just therapists in general, to be thinking
all
about.
Of us.
Absolutely.
Yeah.
Tell me about some resources that you would recommend for people who are listening.
Yes. So first and foremost, always, I recommend AFCC, which stands for Association of Family and Conciliation Courts. And they are sort of the professional organization of all the professions. So, those of us who might be, marriage and family therapists probably belong to LMFT. There's also, the NASW, there's the, APA. AFCC is an organization like that, like a professional organization, but attorneys and judges and law clerks and mediators and custody evaluators and parenting coordinators and therapists and psychologists and forensic evaluators, everybody like that belongs. It's very multidisciplinary. And they have a website. I believe it's just afccnet.org or something. And on there, under resources, they have, I think they call them practice guides.
Cool.
And they have one that is for work with court-involved families. It's like 40 pages. And it is kind of a best practices standards for this work, because there are some things that, you might do within normal therapy that you do a little differently with court-involved families. And this is a resource that kind of spells that all out for you. So it's immensely helpful. And I think anybody who has a court-involved family or individual client should read it. I think that's a great resource.
We'll link to it in the show notes as well, so people can, in the description, so people can click on it and find it. Yeah, absolutely.
Yeah, because I think that's a really just kind of meat and potatoes resource for people to start, especially newer therapists, but all therapists. And then the other class that I recommend to a lot of folks is called the Bridging Parental Conflict class. And it's a class here in Minnesota, but none of it is specific to this jurisdiction. It's about kind of the movement and the landscape of, family systems that are in conflict and how to center the child in the midst of that. And it's just it's brilliantly done. It's my absolute favorite resource for this type of work. And they are doing that class over Zoom and working on, I think, like an asynchronous learning platform. So it's something that would be available. You don't have to come to Minnesota to take the class. So it's something I recommend to parents. So this is a resource that, if you're a child therapist, you could ask both of the parents if they're willing to take the course. It's not super expensive and it's one day. But also, it is an incredible kind of primer for a therapist also into the family systems dynamics. And they do allow, or they have in the past allowed therapists to observe the class for free. So if this is work that you're really thinking like, I'm gonna do this, I would absolutely recommend shadowing that class as a professional. And I would recommend having the parents of the kids that you're working with take that course. And then you and the parents have some common language that I think can go miles. I mean, I think it can take sessions upon sessions to get parents to the place that they can just sort of already be conversant at a particular level once they've taken that class. So I think it's a real time saver in the therapeutic process. So those are a couple resources, for you as a therapist, ethically, clinically more, and then something to give to parents too.
Awesome. Thank you so much for plugging those resources. I know that we've talked in the past about, I love the Bridging Center. I was actually, when I was a child protection investigator, they allowed me to observe the class.
Yes.
Because I was court ordering parents to do it all the time. And I was like, I've heard such good things about this class. I want to join. And one thing to note too is that they put parents in different cohorts typically, so you take it separately. And
both parents take it, but not on the same day.
Yep. Yes. Exactly. And oh my gosh, yeah, I can't speak high enough about that class. It's so helpful and so good. But awesome. Yeah. Any other last thoughts before we head out?
This might be a dangerous one, but I think it'll prove a worthy point. How many times have you been reported to the regulatory board?
Oh, man. I don't know if I can tell you how many times.
More than 5?
5 might be how many times I've been reported to the regulatory board. But I've been reported to the Better Business Bureau, the Minnesota Attorney General, various federal programs. I mean,
so all sorts of places.
All the places, right? Yeah, and I will say that I don't view the board as the enemy. So far they haven't taken any disciplinary action.
And that was my next question.
Yes.
So 5 reports, 0 instances of disciplinary action, and that's because when you document this stuff well, all you need is your documentation and you're covered. And your regulatory board is not out to get you.
Yeah, and I will say I'm lucky because I am an LMFT, and so that board understands the systemic work that I do. I have heard that throughout the United States, if someone is licensed a little bit differently, they might have a regulatory board that isn't quite as understanding, not because they're incompetent, they're just competent in what they do, drug and alcohol counseling or something else, and they don't understand these dynamics. So it can be a little more scary for some folks in different jurisdictions depending on their license. But I've been, here in Minnesota, I think the board is collaborative, and they want the public to be protected, but they want therapists to succeed at what they do. So I'm not afraid of that. And I will say, I think it's probably unlikely that a therapist that's doing this tricky of work throughout their whole career wouldn't make a mistake. I probably will. And then they'll do their job and they'll call me to the carpet and tell me what to do to fix it, right? That's the point, is not that we're infallible, but that we're humble enough to know that. But I will say that this work is going to put a magnifying glass on that, and you're going to get to have the board take a look at it all the time. And so it does you learn a lot about how to practice well. Yeah.
Well, I don't think there's any overstating the importance of this work. So I'm always grateful for the people who kind of run toward the client populations that everyone else is running away from, because if there weren't people running toward them, there would just be people running away from them. So
yeah, and ultimately, who pays in this situation? Kids.
Yeah.
Right. And so it's tough stuff, but worth it. Yeah.
Awesome. Thank you so much,
Yeah,
Deb, for
thanks for
joining.
having me.
And we will have you back soon to talk a little bit more about the different roles that a therapist might play, like, you know, if you're a mom's therapist or if you're a family therapist or, you know.
Yeah, so today we talked about the individual therapist for the child, but there's individual, you know, parent therapists, and then there's these systemic family roles, right? And those get even more layered.
So
That'll
this
be
was
a
just
fun one.
this was just the primer. We'll come back and yeah, thank you so much for joining us.
Thanks for having me.
We'll see you all soon.